guys know you're on mute, it's okay that you are. For now, I just want to make sure. Hello, everyone, and welcome back to our Raising Special Kids Quick Connect Facebook Live series. I'm Brittany Miller, and I'm super excited to be hosting today. The Raising Special Kids team, we are thinking of our families. Right now, it's that busy time where parents are back in school and they need assistance with special education questions. So admittedly, our phones are ringing off the hook, and it's our pleasure to be able to provide support and guidance to families as they call in for assistance. Before we get started on our special edition Quick Connect today, I wanted to remind you guys to head over to raisingspecialkids.org. Our training calendar, we've been packing it full of our fall trainings. So they're free for families, sign up. Topics like IEP trainings, better take that one, positive behavior support, legal options, turning 18, our Triple P parenting program, high school transition, and more. So definitely check those out. They're really worthwhile and helpful for families. You know, when you're more empowered and informed, you can advocate for your child. So let's get to our topic today. So we are really blessed to have Jeff Studer, the Director of Dispute Resolution at Arizona Department of Education, as well as Angela Odom, who is the Director of Program Support and Monitoring at ADE, here with us today. You know, they are friends of the organization. They are constantly supporting us and helping us have the knowledge so we can be better equipped to help you all and the families that we serve. And we're really grateful that both of you decided to join us today. So thank you for being here.
Great being here.
Yep, thank you.
Thanks for having us.
Perfect. So, you know, I gave them some questions in advance. You know, we get questions all the time, especially this time of year on, you know, the special education process and eligibility and what procedural safeguards are and that acronym called FAPE, you know, how to work with your IEP teams and more. You know, lots of parents call us about this. And so we've gathered some questions we've been hearing lately from parents for you both to answer. So let's go ahead and get to it. I'll just go through the questions and you guys can give your feedback.
Sounds good.
So, perfect. So first up, what does FAPE mean? Why is it important for parents to understand this concept?
So FAPE stands for Free and Appropriate Public Education. And that is the basic tenet of the Individuals with Disabilities Education Act. IDEA, another acronym. So it's there to protect children with disabilities and make sure that they have what is needed to be able to access the general curriculum and make progress. So that's kind of the basic gist of what it is and why it's important to know what it is, so that you can know if your children are getting what they need in order to make that progress.
I would say an additional thing for parents to know why it's important too is it's a free and appropriate. So it's not necessarily above and beyond what the expectations are for non-disabled peers. But to kind of level that playing field as much as possible based on the individual student's needs. So FAPE does not look the same for every single child. Even a child with the same disability as another child, the variables are different. So FAPE may look very, very different. And I know we got some questions that are going to talk about services and things later, so I won't go too far into that.
Thank you for bringing that up, Jeff. Sometimes we get calls from parents like, of course, as parents, we want the best education possible, the best services, the best supports. And there's that collaboration that comes with school teams on appropriate versus best and finding the supports and service to help children access the general education curriculum. And so I'm glad you clarified that because a lot of our families need help understanding that. So thank you. Okay, let's keep going. Lots of questions today. So as a parent, how do I know that my child is receiving the services documented in their IEP that they're entitled to? And, how are the special education goals and services determined?
Let's start off with that one because in dispute resolution, we do a lot of different things with some investigations and specific to service delivery. And I think one thing Angela and I and all of Exceptional Student Services would agree on is that communication between parents and schools and the entire IEP team is very important. And you're going to know based on just having that open communication with the special education teachers, the gen ed teachers, just to know what's going on, just to the point of kind of like a check-in type of thing. But you're also going to receive periodic progress reports, which are going to report on your child's progress towards the goals that the IEP team has established. Doesn't mean that if there's no progress going on, that services aren't being delivered. But it is one of those kind of barometers where you can kind of to weigh what is happening. And sometimes you may need to go back to the drawing board as an IEP team and add additional services and those types of things if that progress isn't happening over time. But it's going to take time, but open communication, I think, between all team members that are working with your student is the most important thing of all.
Very true. So, and just to, emphasize what you said earlier, some families wonder, like, if my child has autism, for example, is there a standard IEP for autism? The answer would be no, right? Like, it's very individualized.
Correct. And with dispute resolution, we look at specific allegations and specific files. Programmatic monitoring looks at an array of files with the same disability category. So Angela could probably address that a little bit more about what happens when we see the same documentation, the same services in a similar IEP.
So Brittany, to your point, and Jeff already mentioned this, every child is unique and they have their own unique set of circumstances and their unique set of needs. So we don't expect that even if we look at 3 or 4 files where they're all children with autism, let's say, that we don't expect their programming to look the same because we don't expect those 4 or 5 children to all have the exact same set of circumstances and same, unique needs. So we definitely expect that those IEP teams are meeting and they're determining what is needed for those children individually, not as a subset or, a certain type of disability.
The best way to put it, and we give this feedback to any of the constituents, parents, schools, advocates, attorneys, RSK. There's no grid out there in special education land that says if this disability category, then this service and this goal and these accommodations. Again, it goes back to the individual need of that student. And it could drastically vary from student to student where some stuff is, kind of minor services compared to a student who has a similar disability whose situation may be a little bit more involved that requires more services, more accommodations. And those and related services and those kinds of things to help that student access and progress in the general curriculum.
Thank you. That was really helpful. We do get a lot of questions surrounding that. So thanks for the clarification. So these next 2 questions are regarding, the medical diagnosis versus special education eligibility. And admittedly, I think we get a phone call a few times a day about this at Raising Special Kids. So first part, can a medical doctor prescribe special education services? And then secondly, how does the medical diagnosis affect, the consideration for special education eligibility?
The first question I think we can answer with the question in the inverse is, can we diagnose the flu as special educators? The answer to that question is yes, because we've been around kids long enough and we know what the flu looks like. Just kidding. No, we call these prescription pad IEPs. Medical doctors are experts in the area of medical, and medical diagnoses are different than educational disability categories. So can a doctor say, Jimmy needs a IEP, love Dr. Jeff? Here, give this to your school, and they're going to automatically have an evaluation to determine eligibility and write an IEP. Absolutely not. But
Thank you, Dr. Jeff.
but that doesn't mean that it should be ignored. First of all, it also doesn't mean that just because a child, let's say, has ADHD, that they actually need special education. So schools should be aware. If as a parent you want to make them aware, but like Jeff said, it doesn't necessarily mean there has to be an evaluation, and it may not rise to the level of, it may not be debilitating or impacting the child to the level that they require that special education or that specially designed instruction. So, the child has to have a disability, but from an educational standpoint, in order for them to require an evaluation or an IEP, it has to be impacting them in the classroom to the extent that they require that specially designed instruction.
I think to be more specific, and what we answer the question mostly on with that is there's a medical diagnosis for autism, and there's an eligibility category under IDEA for autism. The two criteria are different. And what Angela said there, just at that last part, is important because, first of all, for a multidisciplinary evaluation team to determine a student is as eligible under the category of autism, there's criteria that the data needs to show for that particular student. The second thing is they call it a two-prong, but it's actually a three-prong. So they have to meet the eligibility criteria, one. Two, that disability has to impact the student's access and progress in the general curriculum. Before you get to that third question, which is, does that student need specially designed instruction related services in order to access that general curriculum and make progress in the general curriculum? So there's not a rubber stamp kind of thing where my doctor says my student has autism, so I want you to develop an IEP for that. But it is information that an evaluation team should consider if there is the decision by the PEA to move forward with an initial evaluation or any reevaluation if there's additional medical documentation that comes up through the course of that student's educational career.
Thank you. That was super helpful. Moving on, this is a myth we hear all the time. So I wanted to ask you guys this. So as a parent, I attend my daughter's IEP meeting, we come to an agreement, we develop the document. Do I physically sign off like, yes, I agree with this, and then it's implemented? Do parents actually sign the IEP?
So I'll go ahead and start off with this one. Certainly parents can sign, and a lot of schools may ask you to sign. They're asking you to sign to evidence that you participated in the meeting is what they're asking you to do. Arizona does not require parents to actually sign off in order for the IEP to be implemented or the evaluation for that matter either. However, lots of schools and districts use that as a way to evidence who participated in the meeting. So that may be why you're asked to sign.
Yeah, and I'll say just from the perspective of if there was a state complaint about a parent not being invited to participate or not taking part in the educational decision-making of their child, we do more than look for signatures. Signatures are not required. There are other times where signatures are required, but that's a completely different question. But we have the ability when we're conducting an investigation that if we see names and the roles that those people played on an IEP or an evaluation, we go and interview those people and we ask who they physically saw at that meeting. So the second part of the question is it physically signing off and saying, yes, I agree with everything in this IEP? It's not a contract. And that's, I think, some misconception as well about what an IEP is. The school's not signing off as a contract, nor is the parent. What it is it's a document that is reasonably calculated to provide that student with the FAPE. There's no guarantees when it comes to IEPs. It's the best laid plans that team that includes the parent has come up with. So it's not saying I totally love this IEP, it's the best IEP ever, and I'm going to sign my name to it. It's essentially just saying I was here, I participated, I had input, and I'm good to go.
Thank you. We get so many questions, and often that kind of cycles around social media. So thanks for dispelling that myth so we can understand that. Speaking of team members, who is required to be at an IEP meeting? And then can someone not be in attendance? Like, can someone excuse themselves, and could the school still hold that meeting?
So the law requires that the participants at the IEP meeting, there's 5 required and then potentially 6. Hopefully I didn't do my math wrong. So the parent is a required team member, a general education teacher of the child or potentially of the child if they're not participating in the general ed classroom. The special education teacher or provider, if the child maybe is only receiving, let's say, speech services, it might be the speech and language provider as opposed to a special education teacher. The PEA representative, so public education agency representative. And then, who did I miss? Oh, a test results interpreter. So the test results interpreter is somebody who can actually speak to different data points that may be related to assessment information about the child. And then the student is also a required member if they're of transition age. So if they're of age, usually by age 16, sometimes earlier, the child is included in that process as well.
Or anytime secondary transition is being discussed.
Yep.
To go back real quick for that public education agency representative, that's a kind of, there's like 2 roles that are actually defined, parent and public education agency representative. Those are the only 2 roles that are technically defined in IDEA. Okay. As a public education agency rep, they have to be cognizant of the school's curriculum. So know what the school has and then be knowledgeable of that. They have to know what the school's resources are, but most importantly, because they're that person at that meeting who says, I am the school representative, I say that we have these resources, and if we're putting them in the IEP, then those will be provided. So essentially, knowledge of what's available, knowledge of the curriculum, and the bestowed upon by the district or charter school to commit those resources to that student for that IEP.
Okay. And on that question, just side note, sometimes we get calls here at Raising Special Kids where parents said, I had an IEP meeting, but the teacher wasn't there or the occupational therapist didn't show up and I really needed them to be. What should have happened in that situation? Are they allowed to be excused for it to be an actual IEP meeting?
So it depends if they're not fulfilling, if all 5 of those roles that I mentioned are represented at the meeting, then other people are considered extra, let's say. So okay. The OT might be extra. If I'm a high school student and you're holding my IEP meeting, I probably have potentially 6 teachers maybe that you could call upon to be present at that meeting. So, and they're not all required. So if I'm a parent and I really want information, from the horse's mouth, let's say, and it's the OT and I don't know if they're going to be at the meeting, you could certainly ask the school to see if they're able to come to the meeting. Keeping in mind, and this may be something parents aren't aware of, but a lot of those folks, especially your related provider type of people, so speech, personnel, OT, physical therapy would be another one. A lot of times they're hopping around from across multiple schools. And so I would imagine if they can be present, they will try to be present, but that may not always be possible. So they could certainly also ask for a written input from that provider specifically, so that they can at least get some insight if they're concerned that they're not getting any communication or they don't know what's going on. That would be another thing that they could actually ask for in advance.
I think it's important to note too that if one of the required members, and a lot of times it's a gen ed teacher, it is allowable within the IDEA to excuse that member, but the parent has to agree to that excusal. So, and it has to be done before time. And IDEA is not full of a bunch of black and white deadlines. So you could walk into an IEP meeting And the person who's facilitating that meeting could say, hey, by the way, the gen ed teacher couldn't be here, but we've got written input and we got their information here that I'm going to present for you. Are you okay with that person being gone? And you could sign off on that at that time, 2 minutes before the meeting starts, and that would be prior to, and that would show the agreement. So it doesn't happen very often. The other thing I do want to note, just for parental knowledge, because we get this a lot in complaints, is the parent doesn't get to choose what school personnel show up to that IEP meeting. That's the choice of the public education agency. Yeah. So if you have a high school where you have 6 different teachers and you want this teacher and this teacher, but you don't want those 2 teachers, hopefully the school is not acting just to irritate and aggravate and brings those 2 teachers that you don't want, but they're going to bring the teachers that they feel are most appropriate because the information they have are more important. And honestly, we also say it to schools when we're getting the feedback, particularly in facilitated IEP meetings, which we'll talk about later. Sometimes you have a better rapport with those teachers, and that's fine. But it's different to request or ask than it is to demand. And if you provide a reason, essentially saying that I just have a better rapport, I feel more comfortable, it is a good thing to have that to make the parent, you guys, feel comfortable at that meeting, so you feel confident enough to share that you have a general ed teacher or any personnel there who makes you feel comfortable enough to participate even more openly than what you should already feel.
That's a good point. Thank you. So let's keep moving because we got lots of questions to get to. This is regarding.
We're going until 6, right?
This is regarding independent educational evaluation, so IEEs. So first of all, how is an independent educational evaluation? How is that used to determine special education eligibility? And if the parent requests one, do they have to use the list of providers the school district gives them, or can they choose who does that private evaluation?
So an IE generally comes after, and it is afforded. So parents are afforded to request an IEE by IDEA. So an independent educational evaluation after each evaluation that they disagree with. So it's not generally before. If a child gets evaluated by somebody like a private speech pathologist or other clinic or whatever, the parent brings that to the meeting. That's just an evaluation information. An IE is different. So let's say there's an evaluation, as in your example, in which the parent doesn't agree with some of the information that's contained in that evaluation. And let's say it ends up in an eligibility determination the parent doesn't agree with because they wanted a different category of disability. And the parent thinks that the data is inaccurate. The parent can request that independent educational evaluation. It's afforded to them by the IDEA. The school's requirement essentially at that time is to provide the criteria. And generally what that criteria is the licensure, the level of education, degree, and that they would expect of the same evaluators that would provide the assessments that would be provided to the student in that independent educational evaluation. The list, now schools aren't required to provide a list. Here's a list of some evaluators that you could use. There's no requirement in the law that those people on the list are who the parent has to choose from. What is required is that if the school sets the criteria, that's the same, not above, but the same as what they expect of the own evaluators that they would hire or contract with, then that's who the parent would have to bring forward if they were going with somebody off of that list.
So I have a quick question, Jeff. So you mentioned the IEE can be used if you don't agree with like the findings or the eligibility category. What if they found like my child not eligible after evaluating them? Could I request an IEE there?
Yeah, so when we say eligibility determination, so it could be category of eligibility, or it could just be that the child was not found eligible at all.
Okay.
And just to kind of go with what I think your second question is what is that used in determine eligibility? After the fact, the law only states that the public education agency needs to consider that information to determine if it changes possible eligibility or if the student's already eligible, the provision of FAPE. So it's not necessarily we're all going to get back together and we're all going to have a discussion with this, but it should be a consultation between the school and the parent. Doesn't mean the entire team convenes. Doesn't mean it's a new evaluation meeting. Doesn't mean it's a new IEP meeting. but it's to kind of go over that information and say it really doesn't change things, or hey, we didn't see this in ours. Let's do this and add this to the IEP. So
Thank you. We get so many questions about that. That was really
Yeah.
helpful. So shifting gears, are IEPs only needed for academics? We have parents call us and say, my child was denied a special education evaluation because they have good grades. Is that what it's all about?
So I would say this goes back to when we were discussing earlier, kind of those three prongs, right, to making an eligibility determination. So the child has to have a disability, one of the disabilities outlined in statute and IDEA. The disability has to be impeding their progress in the general curriculum to the extent that it requires specially designed instruction. So the team has to kind of make that determination, and they have to be able to justify, each piece of that in order for a child to be eligible for special education in a school setting.
Okay. I think that question often comes up when the parents are concerned about their child's maybe like severe social deficits and then impacting their day. So dependent on those factors, do children get IEPs sometimes when they have those needs?
So it's not just the looking at the grades kind of thing, because a student can have some serious deficits in other areas like social, emotional, behavioral type of stuff that may not show and reflect in the grades, but there's no guarantee that that won't have an impact down the line. So really that's a discussion that happens during that evaluation process between that multidisciplinary evaluation team that talks about that impact. Quick example, when you're talking like K-3 articulation, when it comes to speech, articulation often doesn't impact that student's access and progress in the general curriculum, but that student is still determined eligible as a student with a speech language impairment and receives an IEP, even though it's not really impactful with the grades. What that becomes is the discussion of, okay, so let's just say the student gets beyond third grade, goes to fourth grade. We don't correct the articulation errors, and they're making the WR substitutions when they're a 7th or 8th grader. Will there be a social stigma attached to that? Will that lead to other types of behaviors and stuff to avoid participation, to volunteering to read, to answering questions, to do those? And now all of a sudden you start seeing the impact on the grade. So it's not just what the grades say now, it's the overall impact that it could have on that student's access and progress.
Thank you. So we get questions from parents who have, junior high, high schoolers heading into those older grades. What is transition planning? When should that start, and what does that look like?
So transition planning is, it's a huge component of the IEP for children. It's required. Let me back that up a little bit. It's required under law for the IEP that is in effect when the child is going to turn 16. Okay. So let's say the child's going to turn 16 in October, and their IEP was done in May, so it's going to span through October, and it doesn't need to be reviewed again until the following October. So in that situation, the child would have been 15 when we met in May, but they're going to turn 16 in October, so that they would have to do transition planning. So it's required for children 16 and older, or turning 16, depending on when that IEP is written. It has 8 different components, so there's a lot of pieces that go into this. A couple of the key pieces are the post-secondary transition goals. They are required to be there for every student who's over the age of 16 and older, and in the areas of education or training, as well as employment. So at minimum, they need to have those 2 goals. And then there has to be data to support why those goals were chosen. So, and I think that's important for parents to understand, because sometimes, kids have their own dreams of what they want to do, and parents might have their own dreams of what their children want to do. But in the IEP process, it's really important that data is collected that actually supports those measurable post-secondary goals, so that the school can aid the child in planning and make sure they have some of the skills necessary to hopefully achieve those goals. And that's why data is really important. So there's a lot of pieces that go into it. But it is part of the IEP process, and it should be encompassed in that process, drawing off those present levels, the goals, all the other pieces that parents would already be used to helping, in that IEP process.
I'll just add real quick that I'm not plugging for a future session, Facebook Live, but we could.
Writing that down.
Secondary transition, although it's a part of IEP for students at the age when they turn 16, like she says, it can be started earlier, but transition is a whole different beast and something to consider that we could do one of these sessions on that talks about the components like Angela just briefly touched on. But I will say that one of the tenets of free appropriate public education is regardless of when that student is actually identified, whether it's 3, 6, or 16, the whole purpose of FAPE and an IEP that's reasonably calculated to provide that FAPE is to prepare that student for a successful post-secondary life. So that should be conversations that you're having. It's never too early to start talking about what we're going to do when we grow up. I'm still talking about that myself, but so you can start talking about those things and having those IEPs reflective and building those skills, because that's really what it's about. But as far as the 8 components, we have trainings that Angela and I have done together in the past that we can get into that, but almost everything in here we could talk about in a completely other session. So, and that's one of the major ones.
We're throwing a lot at you guys. We appreciate
That's fine.
but I won't forget that you offered to come back. So
I know, and it's on tape apparently too. So we'll get that.
Everyone. And we do have a great high school transition training parents. So if that's something you want more help with. And I should mention too, if you have questions about any of the concepts that Jeff and Angela have shared today, please reach out to Raising Special Kids. We'll put our contact information in the comments. We want to help you. We can help guide you and get the information you need so you can help your child. So know that we're here. I'm actually excited to talk about this next thing, Angela. A lot of parents don't realize that their school district has a program specialist they can call for assistance. Can you talk about that for a little bit?
Sure. So every charter and district in the state of Arizona has an assigned program support and monitoring specialist. We are tasked with a piece of the required general supervision that's in the federal law in terms of what the state education agency is tasked with doing under IDEA. And they are, that can be a first point of contact for any constituent that has questions related to that charter or district. They are only going to be able to provide guidance related to IDEA legal requirements, but they do talk to parents all the time, so they can put it and should put it in terms that parents can understand. We handle all constituent calls, regardless of whether it's school-based personnel or a parent. The same, meaning you're going to get the same answer. So if you pose me a question and it's the same question that a school calls me with, I'm going to give a parent the same answer. I just may explain it in some different terminology so it's easier to understand. That said, we cannot advocate, and we definitely work in collaboration with Raising Special Kids, and we refer parents there all the time because we know you guys are a great resource and have lots of trainings available. And we can help with contacts at the school or district, because a lot of the charter or the district, a lot of times we're going to know who the special education director is, so we can at least connect you up the chain locally. Sometimes that's difficult, I know, to find on websites and things like that. They're a great resource from that perspective. They can give you other resources, explain the dispute resolution options, sometimes in a little more detail, show you where those websites are. So they can provide additional resources outside of ESS as well, depending on the needs of the caller.
Thank you. And to find your district or charter's program specialist, you go on their website. So we'll make sure please check out the links in the comments. We'll have that listed there, as well as our dispute resolution website too, which we're going to get to some of those questions coming shortly. So moving on, facilitate IEPs. This is another
So
one.
here we are.
Yeah.
Real quick.
So this is another one. I think parents, when they hear about it, they get excited about it. And admittedly, both of you, sometimes they've never heard of it before. So we're always happy to share it's an option. Jeff, do you want to tell us a little bit about those?
Sure. So facilitate IEP is it's not part of a parent's procedural safeguard rights. It's not part of the state's general supervision responsibilities. It's just an alternative option to help resolve issues at the local level. Although it's not an IDEA and it's not anywhere in general supervision or procedural safeguards, like I mentioned, a lot of states are doing it. And what it essentially is we contract with a few vendors out there who know the IEP process. It's a voluntary process. The schools can request it, the parents can request it, but both parties have to ask for it. And what it is, it's a neutral facilitator who comes in, has a conversation with the school, has a conversation with the parents, finds out what the sticking points are. And really what it just is like having somebody say, okay, Brittany, now it's your turn. We'd like to hear from you. We haven't heard from you on what your ideas are. And hey, Angela, how about, what are you thinking? And hey, Neil, you've been sitting there quietly this whole time. We'd like to hear what you think about it. And it really just helps facilitate conversation. So you get all ideas out on the table. They utilize an agenda. They have parking lots for things, not like a real parking lot, but something where it's like, if you're talking about my kid doesn't like white milk, can you just give him chocolate milk all the time? It's like, well, that's not an IEP thing, but we could talk to the cafeteria staff after that. It's a free type of process, a request, and you'll see it on our webpage when you get to the end of this program and the link. We have a facilitator or an alternative dispute resolution person who can explain it. There's more information online, but it's really just a situation in which if you as a parent don't feel like your voice is being heard, it's the facilitator is not an advocate. They're not your parent advocate. They're not an advocate for the student. They don't work for the schools. They're contracted through us. We pay them to go there to be that neutral person. So what it is, it's about the process. It's about the IEP process and about what the true meaning of developing that IEP is with that IEP team. So we've had a lot of success with this. I think the percentage is about 80%. Facilitations end in at least partial agreement where they were at a stalemate before with just infighting. And it just kind of helps people get out of their own way, both on the school side and the parent side, so they can actually have a conversation and focus on truly what that IEP is about. And it's not the adults in the room, it's that child. So,
you know, I have heard from parents pretty recently that doing a facilitated IEP really helped them preserve their relationship with the school team.
And that's a great point that I didn't mention. But yes, it does. And it rebuilds, because sometimes when we think about it, our own experiences, you know, what happened with you were in school? Were you treated differently? So are you bringing your own baggage to that table? But for the school too, it's like, are you like that other parent or whatever? And it really just kind of helps maintain before that relationship breaks down, or helps to rebuild. It helps us remember what we're there for. And if everybody's open and comes in with that good faith kind of intent to actually, I want an IEP that's going to be reasonably calculated, that's going to provide the student with a favor, my child with a faith. And I have to be open to other ideas, because my ideas aren't always the best or the correct ones, but let's hear from everybody. So we have 5 or 6 different ideas as opposed to just one.
So parents listening, don't forget about that option. And again, it's on the Department of Ed's website. We will put the links in there so you can find these.
Yep. And there's a link in there that you can actually request it online, and we will reach out to you and do the rest of the work, including reaching out to the school. So it's an easy, cheesy kind of thing to do to help preserve that relationship and get to a quick fix.
Thank you. I hope parents take advantage of that. So next up, what is a state complaint, and when would it be appropriate to file one? Like, what are some examples or reasons why?
Well, if you had facilitated IEPs, then we wouldn't have state complaints.
True.
and there's not one has to go, so you don't think you have to do a facilitated IEP before you can file a state complaint. So a state complaint, it's more about what we can look at and what we can't look at. And like Angela said, with programmatic monitoring, we look at IDEA. So a state complaint, we look at the procedural requirements of IDEA that essentially says, our services being provided. I requested an evaluation for my child. Did they provide me with a prior written notice 15 days after I made that request to refuse, or did we begin that? So it's procedural things like that. Did the initial evaluation get done within 60 calendar days? So it looks at, here's what the law says you have to do, and here's the framework in which we would investigate that. So it looks at the documentation, interviews with the complainant, and anybody can file a complaint. It doesn't have to be the parent. Sometimes we've had members of the actual schools file complaints on behalf of a student. State complaints are also available to file on behalf of a group of students. Like it could be that a group of students at this particular campus weren't receiving speech services for a number of months or whatever. Complaints cannot be anonymous, so they have to be signed. There's some criteria, and when you go onto the state complaint webpage, it'll explain everything. So what's as important as what we can look at is just as important to what we can't look at. So we don't, and the basic foundation is like if the principal's mean to you or the teacher's not calling you back in 24 hours, that's a school type of thing that you need to go through those administrative channels. If it's something that rises to a moral or illegal conduct or unprofessional conduct for a certificated individual, that would go through the State School Board of Education's investigations unit. We don't look at anything that's related to 504 plans, which are different. That's a different set of body of law than the IDEA. We don't look at anything that alleges discrimination. That would go to the Office for Civil Rights. So there's a bunch of different things, but I'm saying that, but at the same time, if there's a complaint that has one little nugget of something that we're going to look at, and there's all these other allegations of things we won't look at, the complaint investigator that would be assigned to that will tell you up front that, hey, we're not going to be able to look at these things because it's outside of our authority. But here's the contact information. And once that report, the written report, investigation report, which is due in 60 days from the time of the acceptance of the complaint, it will also include those resources to contact Office for Civil Rights, or here's the information for the investigations unit, or hey, this has to go up the administrative chain of command at the school. So it's 60 days. I will say facilitations happen quicker than the 60 calendar days we have to complete those investigations. Mediation, I think, is going to be a question coming up. Those things happen a lot sooner. So it can take up to 60 days for the investigation. And I will tell you, from the perspective of compliance versus non-compliance, about 70% of the time the schools are found in compliance. And I will caveat or note that with, it's not because we work for the schools or the schools work for us. I say what it is because usually complaints happen because there's a lack of understanding about what the requirements are. So we try to help as much as possible in the writing of the investigation report. But if you were contacting your program support monitoring specialist, you know a little bit more about what the laws requiring the schools to do. But even more so, let's go back to the local level and encourage that relationship and that communication between you guys as the parent and the school, so that you really understand what that special education process is, and you're looking for that education, that program that's going to allow that access. We all want the best, but there's a lot of times in investigation reports where it is based on, although the parent wanted more, which we will not fault, but the law says that this is the requirement, and that's really what we got to stick to. And I think that goes to what Angela's saying is the jargon's different, but the answer is always the same, because we base in programmatic monitoring and dispute resolution. All our answers are based on the law. And a school will get the same answer as an advocate, as an attorney, and as a parent.
I'm really glad you defined like what would be appropriate and what wouldn't, because we do get a lot of calls, and you're right. I mean, sometimes it's hard to know, like, would this be for OCR? Would this be for a state complaint? would it be better to talk with the school? So parents, utilize those options, talk to your school, then program support and monitoring if you need to, do a facilitated IEP, the state complaints there if you need it, but it's good to know why it's used. So thank you. Okay, keep it going. Mediation, you mentioned it. So what is it? And questions we get surrounding it are, what is the process like? Is the decision made in mediation binding? And what if parents can't come to an agreement? Those are some things we get surrounding mediation.
So great. So just like facilitation, mediation is voluntary, and either the school or the parent can request it. And just like facilitated IEP, the state of Arizona Education Agency, which is us, AD, contracts with vendors to act as mediators. It's a no-cost type of option. Unlike facilitated IEP, mediation is a procedural safeguard right that's afforded to you as the parent and or a student, adult student with a disability. So this is more of one of those situations where there's an agreement, there's a decision that's made, and you don't agree with it as a parent, and you don't feel like the school's listening to you. So this is after the IEP meeting. Now we're into the point where it's like, I think my student needs more services than what they're getting. I think we got this, or this should have been added, this shouldn't have been taken off. Because remember, IEP decisions are based on consensus. And so consensus essentially means everybody can live with that decision. It's not a popular vote. If that were the case, you guys would be bringing your whole neighborhood and your family, and the school would be bringing all their staff, and you'd have IEP meetings at football stadiums. So it's not a popular vote. It's essentially those required team members that Angela mentioned earlier before talk about things, come to a decision, and they can live with that decision. If the decision can't be arrived at through consensus, the person who has that authority goes back to what we talked about a little bit earlier, is the person called the PEA representative, the Public Education Agency representative. That's the person in the IDEA who we talked about the definition, has the final decision-making power in that IEP team based on the information that's provided to say, there wasn't consensus, but here's what we're going with. In those types of situations, oftentimes it's the parent that is the one who's not agreeing with the decision. Sometimes you'll have a PEA member that's also on the same side as the parent. But as a parent, you have the option to have a neutral mediator come in to talk about the decision and what it is that you think and the reasons why. So if that conversation wasn't happening at the IEP meeting, it's just like any mediation that would be in a court of law type of situation to avoid actually going to trial or a hearing. There is an agreement that, remember, the mediator is neutral. They have no decision-making authority. They're not the ones who tell the school or the parent what the agreement's going to be. So there can be some crazy stuff that come up in these agreements, and it's not the mediator to do it. They can help craft that mediation agreement, but they don't have any decision-making power in that. You said, what happens if we don't get to the point where we're able to write stuff into a mediation agreement? Then that's just a mediation that didn't work out. And sometimes that happens. The good thing is there's a high success rate with mediation, just like facilitation, because again, it's a back and forth. And I will say, as I've said to schools, I've said when I presented to RSK and the folks that work there, really what happens in mediations, and we're going to talk due process here, I think, in a little bit. What happens in mediations, where mediations go down the hill, is when we have somebody who's over flexing their role and their authority. And that could be an advocate that comes in and tries to take control of things and just derails things, or it could be a school attorney or an attorney for the parent. And generally what that means, I'm going to go back to facilitated IEP. If either of the parties are entering into mediation without a good faith intent on coming to an agreement, there probably shouldn't be a mediation. You probably shouldn't have agreed to it in the first place. So again, this is an opportunity for us to just discuss the differences, to have somebody there who's not a decider, essentially go between the two and say, how about this? What do you think? What about this? What do you think? Here's a counteroffer. Again, free of charge. It's less adversarial than a state complaint could possibly be, and definitely less adversarial than a due process complaint. And mediations, just like facilitations, can be a mediator can be assigned. Once agreement is obtained from both parties, mediator can be assigned, mediation can be set up within 14 days of that request, as opposed to waiting for a state complaint that could take up to 60 days for that report to come out. So, and it's at the local level. And it's also, as you mentioned, Brittany, with Facilitated IEP, has the opportunity to preserve that relationship between the school and the parents.
Thank you. Well, I know we're taking so much of your time, but I'm hoping you can talk about due process just for a minute and tell parents, what that last, dispute resolution option is.
You don't want due process. Due process, and we had a consultant that we've worked with for many years as a state education agency that always said that nobody prevails in a due process hearing, because it really doesn't, because due process complaints, it doesn't require that an attorney is involved. Oftentimes it is. So let me back up just a little bit. So due process complaint is essentially, as mediation is part of the parent's procedural safeguards. If there's a disagreement, and so it can cover anything, the provision, whether the IEP's calculated to provide the student a FAPE, it can look at procedural requirements, it can look at a lot of different things that a state complaint can't. It's not voluntary, so the parent can file a complaint against the school, or an attorney representing the parent can file on behalf of the parent. And generally, it's pretty covers everything in the gamut. At this point, for lack of better terms, damage has been done. So that trust has been broken. And this is kind of like you've just gone straight to the jugular, and we're just going to make sure that we're getting everything we can and whatever. So it is adversarial. The good thing, even though IDA has not been reauthorized since 2004, we're overdue a little bit.
Yeah.
When they did do the reauthorization, what they did was build in a 30-day resolution period, which means a school during that time after the complaint has been filed, the due process complaint is filed, needs to reach out to the parent to come together to try to work things out. To see if we can, figure things out. Because what's going to happen in the end, if it goes through, and I can tell you, we've got due process complaints that have been going on for over a year. There's a lot of attorney fees involved. Attorney fees can be recovered on both sides of the aisle. So parents can recover attorney fees from schools, and schools have now authority to be able to recover attorney fees from parents, depending on, the complaint itself. Meanwhile, that kid's still in limbo because there's nothing going on in that decision of the IEP, except for stay put, which I think is a question coming up, which would only have to do with a change in placement for that student. And it's only when a due process complaint is filed. So that would be if a student went to a more restrictive environment and the parent didn't agree with that and filed a due process complaint. That student would go back to that original placement that was the last agreed upon IEP, until which time that due process complaint is resolved. Which, in all honesty, that new restrictive difference or change in the student's least restrictive environment could have been the best place for that student, but now because we put that stay put in order, that student may not be receiving that FAPE to the extent they could have if that would have been given a try. So due process is pretty involved. There is an opportunity for both parties to resolve the issue in that 30-day resolution. We broke records last year for everything. So I think we're in the 120s with due process complaint filings, which pales in comparison to the tens of thousands like a state like Pennsylvania gets, because they're pretty litigious. There's only a handful, maybe each year on average, that goes through adjudication in which there's a decision that's rendered by the administrative law judge. So what that means is when people get together and talk and have agreed to enter into mediation and come up with an agreement, or just the school and the parent talk and go, hey, we didn't know this was going on. What if we did this? Because this is what we're talking about. This is the first we knew about it. Because I will tell you, parents, the chain of command is something the programmatic support and monitoring specialists talk about a lot. And it's like, who have you spoken to? And there's a chain of command at every school. And a lot of these due process complaints, it's just like pedal to the metal. We're hitting the nitrous oxide and we're going 100 miles an hour to that finish line because we're going to get it done. But in the end, only about a handful, so less than like 5%, or I would even say 3%, end up in fully adjudicated because we just started talking. So if we were just started talking in the first place, we wouldn't have the due process complaint. We'd have a better understanding, and we wouldn't have to patch up the relationship that we thought we had. And all that could have been done by going up that chain of command, because especially for districts and some charter schools who have a bigger, like multiple locations or actual schools that have like a district office, what's going on at the local level is not really known at the district level. So once that starts getting elevated and escalated up that chain of command, then and only then does that. And I will tell you, just from our experience with state complaints, state directors a lot of times, our school directors a lot of times say, this is the first I've ever heard of this. Is there a way we can figure this out? Or they get into it and decide that, yeah, we screwed up. Let's just like make this right, and we're bad. So again, we could talk about due process a lot. There's a lot involved with it. There's attorney fees. And like I said, with mediation, sometimes when you get attorneys and advocates and those kinds of things involved that don't have the best intent in mind, it becomes less about the student and more about the adults. And I'm going to go back to something we first said in the beginning of this presentation, was essentially, how do you know services are being provided? Continue to have that open communication, and that'll keep you out of any of the, more official, more adversarial types of state complaints and due process complaints, and keep you in that level where maybe you'll need facilitated IEP or mediation, but be open to communication, and hopefully the schools will be open to you as well.
Thank you both. I think we'll end on that note, having the spirit of collaboration, talking with your school teams, parents, if you need help with any of these topics, like Jeff and Angela said, we could spend whole Facebook Lives just on each one. Please reach out to Raising Special Kids, contact your program support and monitoring specialist. We want to help you. Thank you both for being here today. We appreciate your time. This was wonderful. And to all our listeners, we will see you next time. Thank you, everybody.
Thank you.
Thanks, guys.
Bye, guys.